Okay, welcome to our COVID-19 coronavirus in your workplace, what you need to know, presented by Fisher Phillips. We are joined today by Kevin Troutman and Lariza Hebert. Kevin is a partner with Fisher Phillips, a national law firm that focuses its practice on representing management in the area of employment law. He is a member of the firm's COVID-19 task force and co-chair for their national healthcare practice group. I believe he's also a former board member of the Katy Area Chamber. Right. There you go. So happy to have him here. We also have Lariza with us here. She is an associate in the firm's Houston office. She represents clients in a broad range of labor and employment matters, including unlawful discrimination claims, harassment claims, retaliation claims, independent contractor issues, employee leave issues, trade secret litigation, and more. She has litigated before state, federal, and administrative agencies and has participated in dispute resolutions before the Equal Employment Opportunity Commission and Texas Workforce Commission. Thank you both for being here today. For those in attendance, if you have any questions, please designate them to the chat section of our webinar, and we'll be sure to get those answered before the conclusion of the presentation. We are able to send out notes and frequently asked questions in the PowerPoint for today's presentation. We will also be recording the presentation, and we'll have that posted as well to our social media platforms. With that, I'm going to leave it to you two to get this taken care of.
Okay, thank you, Matthew. And we appreciate the chance to talk with you. The COVID-19 crisis, and I kind of hate to use that word, but I don't think there's a better word, has obviously just overwhelmed everything that's been going on in the country over the last several weeks. And so we're going to try to take some time to help you make sense of some of the things you need to know from an employer perspective. So we're going to talk about the CARES legislation because there's some big numbers involved there, and then the Families First Coronavirus Act that was passed in mid-March and became effective April 1st. We're going to talk about another concept beyond the curve, sort of what are we doing now to get back into the workplace and get businesses reopened. And we're going to talk about some safety and FAQ issues that Larissa and I will both walk through. One thing that's important for all of us to remember, Larissa and I were just talking about, is these circumstances are changing, evolving continually, and I think that's going to be part of life for a while yet to come. So the rules are also evolving. Somebody told me the other day that they felt like they were standing in front of a fire hose as they were trying to process all of this information because it comes so fast and so furious, but we're going to try to help you make sense of it. So let's start with some of the legislation and we'll build from there. And we'll start with the CARES Act because that's a place where there's a lot of big dollars involved. And I'm going to try to, there we go. The CARES Act is the one that includes the Paycheck Protection Program. And that's the one that a lot of folks want to know about. It includes small business loans, and it's intended specifically to help keep folks on the payroll and to help with some other costs. But the payroll costs have to be 75% of the total amount expended if you get these loans. Otherwise, that would at least reduce, if not eliminate, your ability to get the loans forgiven, and that's an important part of this. The Paycheck Protection Program, I'll call it PPP, does not include, this money does not include those initial benefits that were passed and became effective April 1st for the emergency paid sick leave, the EPSL, or the emergency FMLA leave. And Larissa and I are going to talk about those in more detail in just a few minutes. But for now, the important thing is that these loans are available. Folks are still applying for them. A lot of people already have their money now, but the loans can be forgiven. That's the key thing that employers want to keep in mind. The loans can be forgiven. You want to make sure you meet the rules in order to have those loans forgiven. The amount of the forgiveness will be reduced. The amount of forgiveness will be reduced if you reduce your headcount or lower your compensation, your payroll of your employees by more than 25%. So that's a very important caveat to keep in mind. That reduction can be completely wiped out if you restore your payroll and rehire those employees by June 30th. So there's a lot of moving parts there. The deadline to apply for these loans is June 30th of 2020. And these provisions specifically, the PPP and some of the other things we're going to be talking about, only apply to businesses with less than 500 employees. So for larger companies, there are other forms of relief available, but not this PPP program. But lots of companies have participated in it, and that's been a big topic of conversation. The eligibility for loans was based in part on whether the business was operational as of February the 15th. And again, there's specified reasons that the money needs to be spent for in order to recapture or to get forgiveness of the amount that's borrowed and convert that loan into effectively a grant. So that's a quick overview of the PPP, and we'll be available to answer some questions later on about it. But let's also talk about the act that went into effect on April the 1st. Those provisions are temporary; they're just for this year, but those provide for paid and unpaid leave for coronavirus-related reasons. So there's the Emergency Paid Sick Leave Act that I'm going to talk about, and then the Emergency FMLA that expanded the existing FMLA, and Larissa's going to explain that in a few minutes. There's also the increases to unemployment benefits, where the federal government taxes $600 a week onto whatever state benefits that individuals can apply for. Employers can get reimbursement for these benefits that we're talking about, these paid benefits, through tax credits, and we'll explain that. Again, this emergency paid sick leave, or EPSL, applies to companies that have less than 500 employees. There's no minimum days or number of hours that an employee needs to be working for you to be eligible for this EPSL. Again, I'll emphasize that it seems like there's so much information coming out so quickly that this is hard sometimes for companies, particularly smaller companies, to digest. But this is an important one to keep in mind, because, as we'll talk about, there are already lawsuits being filed and more lawsuits being lined up with employees claiming that they've been denied benefits to which they're entitled. So you want to pay particular attention to this. There are specified reasons that allow employees to receive this EPSL benefit. If they qualify, full-time employees can get 80 hours of this paid sick leave, and part-time employees can get the number of hours that they've been averaging over the past 6 months, whatever that turns out to be. And you literally go through the calculation to determine what the hours per day were, and you convert that into the week or the 2-week period that you're paying to determine the number of hours that the employee is eligible to be paid. Now, what are the reasons that an employee can receive this emergency paid sick leave? Well, here they are. The first one is the employee subject to some sort of a federal, state, local quarantine or isolation order. That includes shelter in place and stay home orders. So if that is the reason, and we'll talk about that again in a second, if that's the reason that the employee cannot work, then they would be entitled to this benefit. Why are we talking about this now, with the opening up activity beginning to take place? Well, not everybody's open, and there's some nuances to this rule, and employers need to know that if they had someone who was unable to work for this reason, going back to April 1st, and they haven't already paid the employee, they need to, because that's something that they'd be entitled to under the law. So you need to make sure you pay attention to this and account for it. Reason 2 is if the employee has been advised by a healthcare provider to self-quarantine due to some concern related to COVID. And again, that can be fairly broad, but there needs to be a healthcare provider who provided that advice. And that healthcare provider in this case is a fairly narrow list. This would be doctors, nurse practitioners, physician assistants, not the broad list that we'll talk about as far as healthcare providers who are exempted from some of these positions. This goes back to who's a healthcare provider who could certify the need for FMLA leave when that comes up. So that's an important difference. So the employee has been advised by a healthcare provider to self-quarantine. The third reason is the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. They don't have to have had a medical diagnosis yet, just they have to be seeking the diagnosis. So when you're collecting documentation to help you support the reason for paying this benefit, and then for you to claim the tax credit that goes along with it, you're going to want to capture some information about the dates the employee is claiming, the reason they're claiming they're entitled to this leave, and the name of the healthcare provider from whom they're seeking a diagnosis, or if the case is, say, in number 2, has advised the person to self-quarantine. But you can't necessarily, and you shouldn't explicitly ask for a doctor's note, because that's not provided for here. So that's something to be aware of again. Other reasons that a person can take this emergency paid sick leave is if the employee is caring for an individual who's subject to the order described in reason number 1, or they're caring for a son or daughter if school or childcare is closed or unavailable. And then if they're experiencing any substantially similar conditions, which we haven't had come up a lot, it's really these first 5 reasons that we're seeing. Key question under the shelter in place or stay home orders is whether the employee is unable to work but for or because of being required to comply with the quarantine, isolation, stay home, shelter in place order, whatever you want to call that order. If that was the reason that the employee was unable to work. So if an employee is subject to the order, they're still not eligible for this benefit if the employer has closed down, even indefinitely, whether the reason is lack of business or the business was ordered to close. So if the business isn't there, if there's no work available, then the order is not the reason that the employee was unable to work, and therefore they're not eligible under reason number 1 for this emergency paid sick leave. Again, I know I'm kind of going through a lot of things fairly quickly with you. So as Matthew stated, you're going to have access to the PDF of this presentation so that you can refer back to these things. And we also have a lot of great information on our website that you can refer to help you. So how much do you pay? We talked about how many hours to pay, how much. For the first 3 reasons, the employee gets the higher of either their regular rate or minimum wage. Well, I'm going to assume most everybody's paying minimum wage, so it's going to be their regular rate. Now, the regular rate is really not just whatever that number is in your payroll system. It's the average rate of pay that they actually realized during the period that you're looking back at. So if they were working shifts, or they were receiving some other kind of differentials, not overtime premium, but other kinds of additional pay, then those need to be calculated into the regular rate. Now, for the reasons 4, 5, and 6 on that list, the employee can be paid at 2/3 of their regular rate, so not the full rate. And the employee has the right to supplement that pay. And we'll talk about that again in just a few moments. But the important thing here for you to note also is these benefits, the emergency paid sick leave, capped at $511 per day or $5,110 in total for reasons 1 through 3. And it's capped at $200 per day and $2,000 in total per person for qualifying reasons 4 through 6. There are some exemptions to both of these provisions, the EPSL and the EFMLA. Healthcare providers and emergency responders can be exempted by their employer from being eligible for these benefits. And I've worked with some healthcare providers who have exempted their employees from some of these benefits, not necessarily all of them. The Department of Labor has encouraged employers to be judicious in approaching this exemption and applying it carefully, but they can help. The employer of healthcare providers can exempt them from these benefits. Who's a healthcare provider? There's a very broad definition here. If you work in a doctor's office, for example, you're probably going to be considered a healthcare provider. That's the way the classification is described. The important thing to understand here too is that this is not an automatic exemption. The healthcare employer has to decide to exempt those healthcare provider employees. So it's not something that happens automatically. It needs to be documented. It needs to be explained to your employees, because there may very well be some employees who think they're entitled to this benefit and will be asking for it. Again, it's in effect all the way through the end of this calendar year when applicable. There's also a small business exception for companies with fewer than 50 employees for this one reason. If the leave to care for a son or daughter for the care not being available would create such a hardship that it would jeopardize the viability of the business as a going concern. Again, that's not automatic. Don't make the mistake of thinking, oh, we have fewer than 50 employees, therefore we don't have to worry about this. That would not be accurate. So make sure that you walk through these reasons and you're prepared to support the reason if you decide that you want to try to take the small business exemption. It's not automatic, and it's not just, do you have less than 50 employees? Again, this is essentially what I talked about. The Department of Labor encourages employers to be judicious when using its definitions to exclude providers or emergency responders from taking these benefits. The idea is to balance the need to fight the battle against COVID-19 with the individual needs of the providers or the employees who may need the benefit, and that's the challenge that employers face. So it's not automatic. It's something you want to think through and work through that list and look at some of the particulars in deciding whether or not you would exempt some of your employees for that reason. This is another important point. If you already had a policy in place where you provided paid sick leave to employees before this FFCRA passed, the Families First Coronavirus Act, if you already had those benefits in place, then you cannot require employees to take that benefit first, and you can't change that existing paid leave policy on or after the date that this act was passed. So that's an important provision to keep in mind. Does that mean that employees can, in effect, take both? Yes, it does. Those are two distinct benefits. So if you already had that policy in place, that remains in place, and you cannot change it. Some other things just to keep in mind is, again, this is limited to 2020. It doesn't carry over to 2021. An employee may first use this paid sick time before other paid leaves. That's their option. The employer can't require the employee to use other paid leave that you've provided before accessing this. So that's just an important thing to keep in mind. That's not a battle that you want to get into. Employers have to post a notice explaining how this law works and what the benefits are. The Secretary of Labor created a model notice that you can use, and we have an example of it here. It's on the Department of Labor website. Employees still have to use and follow your notification of absences policies, so they're not exempted from doing that. So if somebody just stops showing up, that's not okay. They have to communicate with you and let you know the reason they're absent and a little bit more about what's going on. Again, this became effective April 1st, so employees can claim a right to this benefit going back to April 1st. The Department of Labor website has a lot of Q&As out there, and again, I will tell you, look at our website. We've put a lot of time and effort into putting a lot of free information out there, so feel free to take a look at that. Here's an example of the notice that needs to be posted prominently in your workplace so that employees are aware of this and so that you're complying with the law. So if you're covered, you need to make sure that that's posted. So with that, I'm going to hand the baton to Lariza to talk about the EFMLA.
Thank you. So like the emergency paid sick leave, the EFMLA applies to employers with less than 500 employees. Many of you may be thinking that you don't normally have to deal with the FMLA, the traditional FMLA, because maybe you don't have 50 employees or don't meet that criteria. However, the EFMLA doesn't have the same barriers. So whether you have less than 50 employees or not, the emergency FMLA will apply to you, even if you are not subject to the traditional FMLA. What the emergency FMLA does is it expands the FMLA on a temporary basis. Employees who have worked for an employer for 30 days prior to their leave and have a qualifying reason are eligible. So you'll remember Kevin explained that to obtain emergency paid sick leave, employees do not have to have worked for the company for any amount of time. There's no years of service requirement or months of service requirement, but here with EFMLA, there is a 30-day service requirement. The CARES Act actually extended that bullet point slightly for employees who are rehired. Now employees who are rehired will also be eligible for EFMLA as long as they have worked 30 days within 60 days, even if they've been laid off or let go on or after March 1st. The reason that the government did this is so that employees who are eventually rehired, if they were let go or laid off during this time because of coronavirus, they wouldn't have to restart their 30-day clock to obtain those benefits. The EFMLA provides up to 12 weeks of job protected leave, and it is paid for after the first 10 days. The unpaid 10 days, however, is a little nuanced, and we'll talk about those reasons in a bit. Notice requirements. Employers do not have additional notice requirements besides that poster that Kevin went over with you earlier. Employees must still provide a reasonable notice to their employers, as reasonable as practical. We recommend, however, that employers aren't so strict on this point because we are all in a difficult situation, and at times it is difficult for employees to obtain, reasonable notice or documentation supporting that. So we recommend even for our clients to just be slightly flexible in that when it comes to a reasonable notice from your employees. Qualifying reasons under EFMLA. An employee may obtain 12 weeks of job protected leave if the employee is unable to work or telework because of the need to care for that employee's son or daughter that's under 18 years of age, if the school or place of care has been closed, or if the child care provider is unavailable due to a public health emergency. Who is a son or daughter? The FMLA definition is going to apply. So there's going to be a lot of situations, and Kevin and I actually have already had clients calling us with really unique and specific questions. Perhaps there's an aunt or uncle or a grandparent who is trying to take EFMLA to care for their grandchild or the niece and nephew. And in those kind of situations, you're going to want to go through the FMLA analysis and see is that employee stepping into the shoes as the parent for that son or daughter. So local parentis. You can always contact your attorney if you have specific questions about that, but that's the relational definition that will apply for EFMLA. So how does it work? The first 10 days of EFMLA may be unpaid. Employees can substitute their unpaid leave with any accrued PTO or vacation that they have, but employers cannot require that they do so. After the first 10 days, employees are compensated at 2/3 of their regular rate. Part-time or irregularly scheduled employees are generally entitled to be paid based on the average number of hours that employee worked in the past 6 months. If the employee has worked less than 6 months and it's a newer employee, then you would take the average number of hours that employee would normally be scheduled to work. Like emergency paid sick leave, EFMLA is capped at $200 per day, and $10,000 in the aggregate per employee. Job restoration and reinstatement requirements. If you're an employer that has 25 or more employees, then the traditional FMLA restoration obligations will remain. And what that means is that the employer needs to restore that employee to their same or equivalent job. However, if you have under 25 employees, then there's a way to kind of get around that if you can satisfy those four bullet points that are on the screen. The employee takes FMLA, the position that the employee held when the leave started no longer exists because of economic conditions or other changes in operating conditions that affected that person's unemployment and are caused by a public health emergency. The employer made reasonable efforts to restore that employee to an equivalent position with equivalent pay and benefits and other terms of employment. And reasonable efforts were made to restore that employee to an equivalent position, but they fail, and the employer makes reasonable efforts to contact the employee if an equivalent position becomes available during the 1-year period beginning on the earlier of the date on which the qualifying need related to the public health emergency concludes, or the date that's 12 weeks after the date on which the employee's leave for EFMLA commences. That is a mouthful, and those are very specific elements that an employer must show in order to bypass this restoration and reinstatement requirement. If you're an employer that believes that they can satisfy these 4 elements to not restore an employee to their position, then we just recommend that with each bullet point, you have documentation supporting those. Additionally, a lot of employers mistakenly believe that if they can satisfy these 4 elements, that excludes them from EFMLA totally, and that's not the case. It only would be an exception to the restoration requirement, not the total EFMLA. We do recommend that employers have a form that employees fill out, whether they are trying to take emergency paid sick leave or emergency FMLA. We recommend that the form have dates of leave, the reason for leave. Maybe it would refer to your policy, because hopefully by now you have drafted a policy, and hopefully by now you have the form too. But if you do not, contact your lawyers or us. But we recommend having the dates, the reason when the employee thinks they can return, having supporting documentation, because you will need that anyway for tax credits. We also recommend that employers have employees certify their reason, and that basically means the employee is promising you that they're telling the truth. Most of you have policies that have some sort of good faith and honesty requirement for your employees. So if you later find out, and I certainly don't want to put any ideas or make anyone paranoid, but if you find out during, EFMLA, someone was on a beach in the Bahamas, there's some action you may be able to take there. EFMLA and interplay with other paid leave. I mentioned earlier that those first 10 hours are unpaid. However, that's kind of nuanced. And the reason that's nuanced is that employee can take any PTO or other leave that the employee may be entitled to from the employer, but they also can use they can utilize reason number 5 under emergency paid sick leave for those first 10 days to be paid. You'll notice probably without us having to tell you that reason number 5 for the emergency paid sick leave qualifying reason is the same reason that an employee can be eligible under EFMLA. So in essence, if an employee is eligible under EFMLA, they're going to be eligible under reason number 5. And so that's why when we say those 10 days, they can be unpaid. They can, or the employee can use any PTO they have, or they can elect to use their emergency paid sick leave during that time. It's important to know that emergency FMLA and traditional FMLA are not 12 weeks and 12 weeks for a total of 24 weeks. It is 12 weeks total. So if you have an employee who perhaps took traditional FMLA earlier in the year, they took 9 weeks, they now want to take EFMLA, that they would only have 3 weeks left. They wouldn't get a whole another 12 weeks. This is the same for the interplay between emergency paid sick leave and EFMLA. It's 12 weeks total. It's not a 12-week EFMLA plus 80 hours of emergency paid sick leave. It's a 12-week total time benefit given to employees.
And as we mentioned, how do employers pay for this? Well, you pay for it, but there's a tax credit that you as an employer can take against your payroll taxes to offset the cost of these benefits. And as I'm sure you've picked up by now, there's a lot of documentation for HR folks to make sure that they are keeping, because when you take these tax credits, you're going to be dealing with the IRS, and you want to make sure that you have documentation to support the tax credits that you're taking. We anticipate there is going to be a lot of disagreements over things and how they've been documented and who's received benefits and who hasn't and how they've been calculated. So the better you can document this and keep records on it now, the easier it will be to sort out later if you have an employee who says, I don't think I was paid right, or they get a lawyer to contact you and say, my client wasn't paid right. So try to keep up with these things best you can. The tax credits that are available, as you can see, they match the caps that are also applicable to these benefits. So you can get tax credits up to the amount of the benefit that's payable under the Act. Down there on the second to last bullet, tax credits for qualified wages are capped at $200 per day and $10,000 per employee. It actually can go all the way up to $12,000 because you get the first $2,000 through EPSL, and then you get the last $10,000 through the EFMLA. So it can actually get all the way up to 12. But those tax credits are going to be critical for you to help save cost, and you want to make sure that your payroll provider and the people that are preparing your quarterly payroll tax reports have access to all this information, and that what they do and the credits they take matches the records that you're keeping. Let's look at a couple of quick scenarios just to talk about how this works. Let's take an employee, Sally, who's been employed full-time for 20 days at a call center that employs 40 people. She's not eligible to receive any paid time off under any of her employer's policies. She has a sore throat and a fever of 100.7, and she can't report to work. Well, she's having COVID symptoms, right? And Sally is waiting to be seen by a doctor. What benefits is she entitled to while she's not working? Well, she's entitled to the emergency paid sick leave, 80 hours, because she's full-time at her regular rate, because that's reason number one. She would not be entitled to the EFMLA because, first of all, her reason for missing work doesn't qualify for EFMLA, and even if it did, she hasn't worked for the employer for at least 30 days. So that's how that scenario would play out. Let's put Sally in a different situation. She's been employed full-time now for 45 days, and they still employ 40 people. As of today, she's accrued 3 days of paid time off under the employer's policies. The school where Sally's 4th grade daughter attends is closed until the end of April. Well, again, this is hypothetical because we're in May now, but Sally's unable to work from home during this time. What benefits is she entitled to receive? Well, she's full-time, so she'll get 80 hours of emergency paid sick leave, but now at 2/3 her regular rate, because this is reason number 5 under the EPSL benefits. She's also eligible for the emergency EFMLA for up to 12 weeks total, that first 2 plus another 10. The first 10 days is unpaid under the EFMLA. It could be paid under the EPSL. So after the first 10 days under the EFMLA, she's going to be paid at 2/3 her regular rate. And she can elect to use her 3 days of paid time off, but she cannot be required to. Now, once actually she gets into the emergency FMLA, the employer can permit the employee to supplement their pay, and they can't even require an employee to supplement if they have PTO available, but that's when they get into the EFMLA. And we can go ahead on that one, Larissa. I don't know
I'm sorry, I think I got dropped from Zoom.
okay, we'll have just a second there while we reconnect. As we get ready to move into this next section, I want to emphasize that we're calling it beyond the curve. We've heard so much about flattening the curve, and this is now looking forward with the lifting of some of the sanctions, or not sanctions, but limitations on what businesses have been able to do. And we're looking at what kinds of things are we seeing happening out there? What kinds of new questions are coming up? And what are some things that you need to particularly watch whenever you're making decisions related to your employees, particularly from this HR standpoint? You're always trying to balance your risks. You've got the risk of being sued, but you've also got a business to run. So part of what we're going to talk about is how do you try to keep those risks in balance, and how do you best protect your company. And while we've got a moment, I want to talk a little bit more about the PPP program, because there's so many issues about that. Like this, we're still having a little bit of trouble connecting to the PowerPoint to the system. But under the PPP, the employees are still waiting for the PowerPoint.
Sorry, working on it.
Sure.
Apologies for the delays, everybody.
There we go. It looks like we're getting there. But anyway, under the PPP, part of what we're going to talk about in a second is there's an awful lot of scrutiny that's going to be applied to these situations. And here we go. Is that where we are? Yeah, we are going to be sending out those PDFs, by the way. So again, we're talking about beyond the curve. Now, what do we do? Well, the applications for these PPP loans, the Small Business Association loans, are open until the end of June. As you probably know, the funds were replenished last week. It seems like it's been longer than that. Some new guidance has been issued by the SBA. We think more regs are going to be coming. But one of the things that's important for companies to recognize now, you've heard about Shake Shack. Who else has been mentioned? The Lakers. There's been commentary out there about different companies who received these PPP loans, and I'm not aware of anything that says they didn't follow the rules. But what I am aware of is that the SBA received some negative publicity as a result of some of those discussions and that reporting. And we believe that's probably caused a little bit of heartburn within the SBA, and they're looking a little more carefully. We're seeing the tone from the SBA change a little bit in terms of them looking carefully and saying, as you see here, Mnuchin has announced that the loans in excess of $2 million, which probably doesn't affect too many people on this call, but those are going to be fully audited. But they're going to be auditing a lot of these loans and looking at, was the loan legitimately acquired in the first place, and how was the money used? So don't get too comfortable thinking, well, we've got our money and that's all we need to worry about. You want to continue to watch this. So some of the questions that are coming up is what if you can't spend all the money in the 8-week period, because the loan forgiveness is tied to spending the money for specific reasons, payroll being the big one, at least 75%, during the 8 weeks after funding of the loan starts. So what happens if you're not able to do that? That's a question that is troubling a lot of companies now, and we've got a team that works on those kinds of issues. You need to try to have that money spent during that period in order to get the forgiveness, but you have to use it for the specified reasons. And if you look down to bullet number 3, beneath where it talks about loan forgiveness, I said earlier, you can get these loans forgiven and you can get them converted into effectively grants. If you don't get the loan forgiven, the payback can be deferred, and it's a 1% interest rate on these loans. So there's some companies that I've talked with that say, if we can get the money at 1%, and we don't happen to get the loan forgiven, we're not going to be all that upset about it. But if you can get it forgiven, you certainly want to. One of the provisions is you're supposed to be, when you're looking at loan forgiveness, the cost incurred and the payments made during that 8-week period after the loan starts to be funded. What does that mean, cost incurred and payments made? Does that mean that either the cost was incurred or the payments were made? That's not what it says. Does that mean that you have to have done both? Unfortunately, that question is still open. The regulations so far from the SBA have not clarified that question. So when you're talking about costs incurred and payments made, it's not entirely clear right now. And we would encourage you to continue to monitor this and work with whoever's assisting you with your SBA, or work with counsel to make sure that you are paying attention to any interpretive guidance that's issued on this question. Because if they were to decide that if the cost was incurred before the 8-week period and it was only paid during the 8-week period, if they were to decide that didn't count, that's something you obviously want to know. I'm not going to hazard a guess. I think the intent of the PPP program was to help employers make it through this period of time. And if, based on the tone we had seen as recently as just a couple of weeks ago, I would think maybe they would interpret that as or incurred or made. But now I'm not as confident in that, so I'm not going to make a prediction there. It's just something to keep in mind. There's been a lot of talk about, well, can you pay employees bonuses? Can you pay them incentives so that they won't want to stay home and collect their unemployment? We would counsel you to be very cautious about paying bonuses or unusual pay that you don't normally pay during this 8-week period. The idea is to keep your employees on the payroll and to keep them busy and engaged. So do everything you can to keep them working in some way for your company during this loan forgiveness period. But be more cautious of bonuses, because those could be disallowed. Now, if it helps you keep your employees and it just reduces the amount of your loan forgiveness, you may be okay with that. But those are things to think about as you're paying your employees. Now, one thing that we were glad to see, there was some guidance issued, I think it was Sunday, from the SBA that made it pretty clear that if you as an employer have offered work to an employee and they've said, no, I don't want any work, I'm going to stay home and collect my unemployment insurance. If they do that, the SBA guidance says that they very well are not going to be eligible for the unemployment insurance. Now, the states are still going to have to process those claims, and each state is a little different. But the Small Business Administration is certainly taking the position that there's a real incentive for you to put these offers of employment in writing and to keep that documentation so you can show you offered the work to the employee. That helps you with the unemployment claims. It also helps you with your PPP program. If you have an employee who you laid off and you offered that employee work and they turn it down, what do you do to meet those PPP loan forgiveness targets so that you can get the loan forgiven to the extent that it's possible for you? What do? The employee was laid off, you've offered them work and they've turned you down. Hire somebody else. Some of the guidance from the SBA says if you do that and you keep good documentation, then that's going to put you in a position to count that other employee that you hire so that you can still work toward that loan forgiveness threshold. So those are some things to keep in mind with respect to the SBA loans. Larissa, was there anything you wanted to add there?
No, not there. My next slide is one of my favorites. So.
Okay. You take it from there then.
Okay. The good stuff. Lawsuits coming from the FFCRA. They're already happening, which may surprise some of you, may not surprise some of you. About 3 weeks ago, we saw our first lawsuit. 3 weeks ago may sound like a long time because a lot of us don't know whether it's Friday or Saturday or Monday right now. It's Tuesday. But that was actually only 3 weeks after the law went into effect. So we were actually a little surprised that plaintiffs' lawyers have already started filing lawsuits under the FFCRA. The claims that we're seeing right now are retaliation and interference claims, denial of benefits. Plaintiffs are claiming that they were wrongfully denied their emergency paid sick leave or emergency FMLA. There was a lawsuit, one of the first ones. The plaintiff claimed that she was terminated after she requested information about benefits under the FFCRA. That one is a little, we're going to see what's going to happen with that one, because in that lawsuit, the plaintiff was actually terminated before April 1st, so before the law went into effect. But she asked about that information after the law was signed, after the bill was signed into a law. So we're going to see whether there's even a viable claim there or not. There may still be a basis for interference in that regard. We're also seeing claims already where employers are forcing their employees to use their PTO before emergency paid sick leave. And like we said before, you can give them that option and employees can do that, but we cannot require that they do so. The elements for retaliation under the FFCRA are going to be the same under the FLSA. So there needs to have been protected activity, which would be an employee receiving or obtaining benefits under the FFCRA. There needs to be an adverse employment action. That's typically a termination, but there are other adverse employment actions as well, and a causal connection between the two. The damages with FFCRA claims should cause some concern for employers because the remedies allowed are the same as those under the FLSA. So this means that employees can receive liquidated damages and attorney's fees. Additionally, like under the FLSA, their individual liability can be imposed to managers and supervisors, and that's because there's such a broad definition under the FLSA of who an employer is. But as we know, the FFCRA is adopting those definitions, and that's why there's individual liability can result. And we actually have already seen lawsuits where managers, even HR people, directors of HR or people who were directly involved in either the denial of benefits or the processing or even just answering questions about FFCRA benefits have been named in the lawsuit. Preventative measures that employers can take to hopefully try and avoid some of these lawsuits that, like we said, have already come. And I do want to mention that a couple weeks ago when we saw those first couple of lawsuits, there was 3 lawsuits in 1 week, and all of us lawyers were like, oh my gosh, there's already 3 lawsuits from under the FFCRA. Now there's been, within the last 3 weeks, there's hundreds. I read somewhere that I think there's over 700 across the nation now. So it's definitely something that we're seeing just completely spike up. So preventative measures, designate an expert internally, one person who really understands the FFCRA eligibility requirements, understands the documentation that employees need to give, is responsible maybe for handing out those forms. Even though we do recommend that you have an internal expert, which normally that is probably going to be, an HR person or, upper management, we still think that all your other managers should be trained so that they don't automatically regurgitate some information that may not be correct and maybe seem retaliatory later down the line, because as we all know, what your managers do and say can affect whether the employer can be responsible under a lawsuit or liable under a lawsuit. Communicate with your employees. Let them know maybe what information you still need or what information they can give you to obtain benefits. The more the more clear you are with employees and on what they need to give you in order to obtain benefits, the better. Document all of these things. We recommend that even though it may not call for it all the time, if you're perhaps terminating an employee during this time or after they've requested benefits or before they've actually obtained all of their benefits during EFMLA, whatever the reason may be, we do recommend you consult with counsel just because FFCRA is so novel, but also document the termination, set in writing why this person is being let go. That way you have something in litigation showing the employer's reason and not just this miscommunication between the employee and employer, because as we all know, there's two sides to every story, and a lot of times former employees have a completely different picture of what went on than the employer. There are also potential wage and hour issues that we are predicting and have already seen some of them. A lot of employers raised or lowered their employees' pay or reduced their pay. For non-exempt employees, typically you can, raise the pay back without issue as long as you're meeting all of the other FLSA requirements, such as overtime and minimum wage and things like that. With exempt employees, however, is where we actually think a lot of these wage and hour issues are going to come in, which is kind of unique because you typically think of wage and hour litigation dealing with non-exempt employees, but we think a lot of these issues will come with exempt employees. Some employers, like I said, lowered salary because of the economic reasons. Hopefully, if you were an employer that lowered an exempt employee salary, you communicated that reason because in writing, like I said before, hopefully you communicated the reason in writing and you have that documented, because the DOL does not like when employers change an employee's salary a lot. They don't like the up and down or frequent changes in salary because, they're going to see it as a way as an employer trying to get around, regulations and avoiding, certain requirements. So if you do have a fair number of employees that you reduce their salaries and you're trying to raise back up, then you probably would find it best to consult with counsel on the best way to do that, especially if you feel like maybe you were lacking some documentation or written communication as it relates to that. Kevin mentioned bonuses earlier. They're problematic during this time for more reasons than one. A lot of employers gave their employees during this time hazard pay, maybe a couple more dollars an hour for working really hard during this time, or any other type of hazard pay. That's all fine, but when hazard pay goes away, there's going to be a drop in morale, and that's just going to happen. And one of the things that can result from that is that's a really great opportunity for unions to try and come in and organize, because unions are going to see that as a takeaway. Neither of us are really experts on that, but if any of you read the news, you probably have already seen that unions are really taking advantage of this time to advertise and market and kind of sneak their way into some companies. Also with bonuses, some employers may bring their employees back, and in order to catch them back up to, the pay that maybe they missed while they were not working or furloughed or had a reduction in wages, they want to give them bonuses. That's fine as long as the bonus is non-discretionary. And if it is, then you need to consider overtime payment in that. A lot of employers are kind of forgetting about overtime requirements during this time. I mentioned hazard pay earlier, and it just reminded me of another thing I forgot to mention. If you raise an employee salary because of hazard, or hourly rate because of hazard pay, some employers are forgetting to take that into consideration with overtime calculations, the extra $2 or whatever. So we recommend that maybe you go back during this time and, audit if you did increase rates or provide hazard pay. Regarding the non-discretionary bonus, what you want to do as an employer is not tie the bonus into anything that's performance related. And Kevin, you might want to jump in here, but generally these types of bonuses are not going to drive a certain type of performance, or they're not going to be announced ahead of time. They're just going to be given from the employer. We're not going to say, come in 3 weeks in a row on time and I'll give you a bonus.
Right. The issue here is calculating overtime, and bonuses, shift differentials, all those sorts of things are supposed to be calculated into the employee's regular rate when it's time for you to calculate overtime. The only exclusion for bonuses would be a purely discretionary bonus. The fact is there are very few discretionary bonuses. A discretionary bonus would be one that the employer truly can give or not give, and a lot of times maybe makes the decision just on a short-term basis or on the spur of the moment even. But if it's tied to criteria, it's going to be very, very difficult for you to prove that it's discretionary. And if it's not discretionary, it needs to be included in the overtime calculation. And this is exactly the kind of thing that plaintiffs' lawyers like to look for, because they can then sue on behalf of all the employees who received bonuses, all the non-exempt employees who were on the payroll during that time. So these are the kinds of things to think about and pay attention to. And the same thing from a different angles, paying attention to our salaried, our exempt employees, because as Lariza said, the Department of Labor does not like to see those pay rates change. And let's say you want to raise salaries back to the pre-pandemic level. What if we have another spike or another dip and you need to lower salaries again? What do? Because that bouncing around can cause the whole exemption to be questioned and potentially disallowed, and that's not something that you want to find yourself doing. So you need to be careful and think through these decisions. There's still probably more wage and hour litigation out there on a consistent basis than almost any other category in at least our part of the state. So that's an important area to look at carefully as you're making changes or doing anything that's out of the ordinary compared to what you were doing pre-pandemic, or as you're trying to restore your operations.
Right, and more wage and hour issues that may be directed, to exempt employees. Some exempt employees are considered exempt based on what their job duties are. If you have changed some of your employees' duties, which a lot of employers have had to do, a lot of employers have had to have employees cover more things, or even just shift their duties wholly based on the needs of the business or economic reasons. If you have some of those employees that are exempt and they're based on job status, then you should go back and look at that and make sure that that employee is still an exempt employee under the law. Similarly, furloughs, time captured by exempt employees, we think that that is already an issue with some of our clients. Furloughed employees, those are ones who aren't laid off but have a reduced schedule. For exempt employees, you need to really look at week per week. So a lot of employers during this time have had their exempt employees work 1 week and then maybe they're off the next week, and they have them rotating 1 week on, 1 week off. However, if you have an exempt employee that on their off week, even worked for a day, that exempt employee should still be paid for that whole week. So just be mindful when you're making those kind of decisions, or if there's a reason that you have an exempt employee who's off and you really need to call him back into work, or him or her, just make sure that you're capturing that time and paying those people appropriately. Temperature taking is a huge issue for so many reasons right now. With regards to wage and hour issues, there's still a question whether that time is going to be compensable, but we encourage employers to consider that time where employees are waiting to have their temperature taken as compensable time. Err on the safe side for now. Ways that you can maybe shorten that amount of time is to stagger your employees' start times. Maybe you have a group of employees at 8, a group at 8:15, et cetera, et cetera. That may help lower that compensable time, but we think you should err on the side of caution because there's not guidance on that yet. And as you probably know, just from reading any news source, the law on temperature taking specifically, as it relates to a bunch of different issues, including safety issues and CDC recommendations and things like that, is changing pretty much every other day. So we might have further guidance from the government on this point, but at this time we don't. So we do encourage you to err on the side of caution.
If you as the employer are requiring those temperatures to be taken, which is probably what's going on, then we definitely think that it's likely that's going to be considered work team, paid time that you need to capture and pay the employees for.
Right.
Regarding these, whatever you want to call them, shelter in place, reopening orders, the various competing orders that we see, we've got orders from the governor, we've got orders from the county judge, we've got orders from mayors. It's important to pay attention to those things, particularly pay attention to the timelines, the dates that are involved, where there's overlap, and are there conflicts between the orders. The governor recently issued orders that effectively said we're not going to fine people who don't wear face coverings after there had been some other localities who had said we're going to make you wear the face coverings and we're going to fine you if you fail to do that. Probably the most important thing to keep in mind here is that the governor's orders, the CDC, some of the local orders, everybody says it's a good idea to use face coverings. So we shouldn't lose track of those kinds of issues. And where there are mandatory safety requirements, most of what the state has said in terms of things people have to do as individuals, a lot of those are recommendations. And now they've set up requirements for restaurants and retailers, who can open, who can't, spacing, distancing, etc. But make sure that you look at what the orders are applicable to your business, and as an individual, look at what the orders are applicable to you. A lot of things. Go ahead, Larissa.
No, okay. I'm sorry. We're so excited about this. That's all it is.
Yeah.
There's a lot to consider with safety concerns. That's what I was going to mention, but I will let you take the hazard communications because you have so much experience on that.
In particular, OSHA requires us to meet their hazard communications standard when we have employees using chemicals. Disinfectants is a good example right now, but anything that might cause them harm, we need to make sure that we're complying with OSHA requirements for communicating with our employees and training them. Same goes for PPEs. We have to document how we determine what PPEs are required, and if we provide those PPEs, and we certainly should if they're required, then we also have to do training and document the training. So there's a lot of things we need to do, and we've always had to do under OSHA. These are just even more prominent now. And I'll tell you that I've seen some things just in the last few days talking about how OSHA is really focusing on some industries in particular, such as healthcare, meat packing plants, some that you've heard about in the news. But everybody should be concerned with what these OSHA requirements are. So especially folks that are handling disinfectants or cleaning solutions need to be trained and made aware of what the hazards are and how to use those agents safely. And you need to have documentation of how you determine what PPEs you are providing and that employees have been properly trained. And Larissa, I know you had some thoughts on a couple of these things coming up, so we'll kind of both talk about some of them, and I'll let you jump on this next one.
Sure. Yeah, with the refusal to work, there's actually a lot of issues laws at play, including the NLRA, which allows employees to come together, basically to engage in concerted efforts to change their workplace or to complain about something in their workplace. And one of those things by law and written in law is unsafe working conditions. Additionally, OSHA, there's a high bar under OSHA for an employee to refuse to work, and the bar is that the employee has to really believe that they're in imminent danger. What that typically means is that they think within a very short period of time the workplace is so unsafe and there's not enough time for OSHA to come in and investigate and inspect the workplace, that they believe that death or serious injury is likely to occur in a short amount of time. So it's a high standard. However, depending on what type of employer you are, that may not be so hard to meet. You know, for instance, if you have an employer who's a morgue that's working with maybe deceased coronavirus corpses, things like that. So that's going to vary based on the type of employer. Always remember that there's a general duty that employers need to provide a safe workplace for their employees. This is going to be the catch-all under OSHA. And a way you can show the government that you are trying to keep a safe workplace for your employees is to follow CDC recommendations. For instance, CDC is recommending face masks when social distancing is unobtainable. We'll talk a little bit about face masks, as you'll see in a couple bullet points. Record keeping and reporting. There's a lot of questions from employers whether they need to report cases of COVID-19 on OSHA logs or to the CDC. And the answer is generally no. Employers don't have to report that. Healthcare providers will report that to the CDC. When it comes to OSHA log reporting, the test is going to be kind of hard to meet because you need to show that occurred at work. So again, it's going to really depend what type of employer you are. And if you're one of the more high-risk employers, then you should, then maybe you have a different requirements than a low risk. And now that I just mentioned the high risk, OSHA actually has really good guidance on 4 different risk categories for employers. And basically what they've done is they've taken different types of businesses and categorized them into low risk, medium, high, and very high. For instance, the morgue employers I talked about earlier, those are very high risk. And what OSHA did is kind of put together a guideline for employers to follow. And what employers can do is follow that and show that they are trying to provide a safe workplace for their employees. And OSHA surprisingly has actually updated it once or twice since this pandemic has, reached the U.S. So I encourage you as an employer to go to the OSHA website and look at what category you're in and then follow those recommendations. Temperature taking, we mentioned this earlier. It's a hot issue, not just for wage and hour, but for safety as well. Some orders, some local and state orders do require this, but generally, if they do not, if you're not under a governmental order to take an employee's temperature, then you do not need to do so and you're not required. A lot of employers are electing to do so anyway and requiring that their employees submit to a temperature screen before they enter the workplace. As of now, that is, they have gotten the okay from the EEOC. That's under the ADA, the EEOC has said that is okay for employers to do. If you would have asked, 2 months ago if that was okay, the EEOC had a bit of a different guidance on that because technically that's a medical exam. Some best practices employers should consider when taking temperatures, since like we mentioned before, many of them is to protect the temperature taker with PPE. This we would typically encourage you to contract this job out to a nurse or other medical personnel, but we know that's kind of difficult to do right now, especially because of the demand of those kind of professionals. But otherwise, still arm your temperature taker with appropriate PPE. Make sure that those people, your employees that are in line, perhaps to have their temperature taken, are 6 feet apart and complying with other social distancing requirements.
Keep privacy concerns in mind too. You've got to always protect employee privacy when you're going through processes like temperature taking.
Right. If you can have the employee who's getting their temperature taken at that time be separated from other employees, perhaps in a room where other employees can't see what that employee's temperature is, that would be great. That's best practice. Also, make sure that if you're keeping the employee's temperature, that you keep records of that in a separate ADA compliant file. Logistically, we talked earlier about wage and hour issues and how it may be best to, if you have a lot of employees, say you have, 400 employees coming back and they coming to work and you need to take their temperatures, staggering those employees so you don't have 400 people waiting outside in line. Perhaps you do 50 at a time. Make sure if you're having your employees wait outside to have their temperature taken in the heat, maybe this occurs in a couple weeks and it's 100 degrees, that you have tents and appropriate stations for those employees as well. The moral of the story is really think about your employee safety when you're taking their temperatures, and think about their privacy as well as wage and hour issues. So there's a lot to think about. If you have questions, reach out to your employment counsel. Face masks are required by some state and local orders as well, and they are recommended by the CDC. There is a question on whether face masks are PPE, and I'm not talking about respirators and N95s. I'm talking about cloth face masks here. If you're going to require that your employees wear face masks, then we recommend that you treat those face masks as PPE and you pay for them. If you're not going to require this and you're not under an order, a governmental order to have your employees wear the face mask, then we recommend at minimum that you allow your employees to wear face masks, because many people are going to go back to work and feel more comfortable if they're allowed to wear face masks. If you are going to require that your employees wear face masks, and like I said, consider it a PPE, and you need to go through the PPE analysis. You need to train employees on its use. You need to perform a hazard assessment, how to clean and maintain the mask, and prepare a plan on the PPE face mask that's reviewed. There's a couple other steps. So if you are going to go down that road, contact your employment counsel. We mentioned earlier labor issues. This is a breeding ground right now for union activities. We've already seen it in a lot of different, with a lot of different employers who aren't maybe typically such a hot spot for union activity. So expect that what you're doing is going to be scrutinized. Expect that employee morale is going to be all over the board and will be, lower on some points. Safety complaints and refusal to work. I already talked about the refusal to work earlier with the NLRA. Employees can come together in a concerted effort to improve their workplace, including with regards to an unsafe workplace.
One point I wanted to make there is keep in mind that unions are businesses, and just like any other businesses, they look for opportunities to increase their market share, to increase their volume. And this is absolutely a great opportunity for them to do that. And some of the unions are doing a fairly effective job of exploiting places where they would say that employers haven't done enough with respect to providing either supplies or caring for the safety of their employees. So certainly be aware of that and respond to safety concerns and issues in the workplace.
social distancing. I know we're nearing our 15 minutes of question times, but the big thing about this slide is it is easier said than done. What every employer is going to need to do is analyze their own workspace and determine how they can safely have their employees back to work while considering the 6 feet social distancing requirement. So a lot of employers, the facilities may not, you may not be able to have all your employees back at once. You may need to think about A and B schedules, or some people perhaps teleworking, et cetera. But make sure you look at your own facility and make your determinations based on that, because you're going to know where your people are stationed, where they move to, break room, you know, dimensions and all of that stuff. So you need to take your workplace and really scrutinize it to make sure that you're going to comply with social distancing requirements.
And keep in mind things, as Lariza mentioned earlier, what time people come in, whether that needs to be spaced out, where people congregate. Are there particular areas that get used more frequently by different people, not just internal offices, but common areas? Think about restrooms and elevators and all the places that your employees are going to encounter during a work day, and literally do a walkthrough to kind of get ready for how is this experience going to work for your employees. And we've really kind of talked about this already, but OSHA is doing these rapid response investigations, which means that they're going to notify employers and ask for documents. These inspections or these complaints can be initiated by any number of people, but all complaints are protected activity. That goes back to the retaliation claims we talked about earlier. This again is a hot button area. The workers' comp claim, and Lariza, feel free to jump in on any of this stuff, but the workers' comp issue, we've seen some lawsuits and some questions out there. Should we get employees to sign waivers when they come to work? We've seen some claims filed on behalf of employees, and frankly, we think some of those claims filed on behalf of employees, tort claims, negligence claims, might just be attempts to grab attention by some plaintiffs' firms, because under the law across the country, workers' compensation benefits are the exclusive remedy for employees who contract illnesses or injuries in the workplace. So in the absence of an intentional act or gross negligence, and this is across the country again, these claims are not likely to get anywhere. Now in Texas and a couple of other states at least, we now have the situation where there are a few employers who have opted out of the traditional workers' comp program, but for the most part, and they should view the situation a little bit differently. The non-subscribers should, but in general, these workers' comp claims are probably not going to get anywhere, and we think it's just more of an attention getter. And we really think that the idea of asking employees to sign waivers before they come into the workplace is not a good idea. It doesn't send a good message. What we need to focus on is complying with OSHA requirements and CDC requirements so that we ensure that we have a safe workplace for our employees, and don't ask them to sign waivers. The waivers are probably not going to be enforceable anyway. So Lariza, did you have anything else you wanted to say on this slide?
No, the only thing I would add is, you know, whether an employee can show that he or she contracted COVID-19 at work is going to be really hard to show, unless, like I said, maybe the employer is a morgue or a hospital. But otherwise, if you're you know, in retail or another type of employer, that's going to be really hard for an employee to prove anyway. But like Kevin said, we think plaintiff lawyers are doing this to get attention and get more clients, basically, to sign up with them. And, you know, we think a lot of those negligent suits may get thrown out. But I think now we might fast forward to answering some questions. Matthew, does that work?
Yeah, that does. We've got a couple here in the chat. If anybody has any further questions, please put them in the chat. I'll go ahead and start with these. If we do not allow work at home as an essential entity, may we require an employee to take a full day off versus a half day? For an example, work in the office 3 days on EFMLA, 2 days per week?
The EFMLA, and I'll ask Lariza to jump in on this too because she talked about that, but the EFMLA would apply to the child care situations. And you can agree with your employee to allow them to take that leave intermittently. Keep in mind that an exempt employee, a salaried employee, is treated differently than a non-exempt employee. So if they're an hourly employee, you can change their hours and you just pay them for the hours they work. If they're an exempt employee, if they're salaried, you've got to be aware of those wage and hour issues that we talked about earlier. But from an EFMLA point of view, you can decide as an employer to allow an employee to take that FMLA leave intermittently, but that's your call. You just need to be consistent in how you administer that decision. I think I've answered that question. Lariza, anything you would add to that?
No, I agree. You're not required to as an employer, but you may allow intermittent EFMLA as long as it works for you, the employer, and the employee. If you go down that road, make sure that you are approving intermittent EFMLA equitably among your employees, because a really important point that we don't want to lose sight of is that there are still other laws at play. There's still your Title VII and ADA discrimination laws that you want to be mindful of. So if you're letting employee A work on an intermittent or obtain intermittent EFMLA, you want to make sure that when employee B asks, that you analyze the situation fairly and, if equitable, give employee B that same type of intermittent EFMLA. So anytime you're making any of these decisions, any FFCRA benefit decisions, keep that in mind, because we haven't seen a lot of discrimination claims yet with the FFCRA, but we will. We've seen a lot of interference and retaliation, but I genuinely believe we will also see a lot of discrimination claims as well that will allege employee A received emergency paid sick leave for child care, and me, employee B, didn't receive FFCRA leave because of child care, and maybe that's because I'm a woman, or maybe that's because I'm African American, and then that's how those other claims will come in and interplay with FFCRA. So moral of the story is just make sure you're making decisions equitably.
Very, very good point. And I just want to mention, you saw this, we have included a lot of FAQs because we know what some of the questions are. So when you receive the PDF of this presentation, you'll have access to those FAQs and the answers. But keep one other thing in mind: these situations are constantly changing. So we're telling you what the answers are right now. They could change in a day or two. So just don't lose sight of that. And again, I know you've got some other questions, Matthew.
Yeah, and just to kind of piggyback on those and additional clarity from the attendee, if an employee takes the FMLA for a full 12 weeks, can they remove job responsibilities even after they return to work? And then I guess part two to that question would be, if they were to remove job responsibilities from an exempt employee as they are on the FMLA and job duties were given to other employees, may they legally reduce their salary?
So there's a slide that we talked about job restoration. And again, remember that when an employee is obtaining these benefits, make sure that they're eligible. They're not just saying, I want this EFMLA. They have to be eligible for that child care reason. But there's a slide that we talked about earlier about what can an employer do to be exempt or accepted from the job restoration requirements under the EFMLA. So the first question is, how many employees do you have? If you have less than 25, then maybe you can be accepted from bringing that employee back to their job. But you need to go through that four-factor analysis, and only then, if you can meet those 4 factors, can you then, change that employee's job or reduce their responsibilities in any way? Otherwise, the traditional FMLA restoration obligations will apply, and that means that that employee will need to be restored to the same or equivalent job with the same or equivalent pay and other terms and conditions of employment.
And there's another important point there related to the EFMLA. If you're paying that employee while they're on EFMLA, then you're paying pursuant to the FFCRA, the Families First Coronavirus Act. The way you pay that employee is based on what they had been earning prior to going on leave. So you couldn't reduce their pay. There's a formula for arriving at their pay. You take whatever their regular pay was, and if they're on the EFMLA, they get 2/3 of that. So you would not be able to reduce their pay under that reason.
Okay.
And if you did, to piggyback again, double time, if you did, I just want to make this clear, if you brought an employee back and when you brought that employee back, reduced their pay or some other term of their employment, that could give rise to a retaliation claim under the FFCRA. And those are the types of lawsuits we've already seen.
Okay. Plaintiffs' lawyers are just ready to pounce.
Mm-hmm.
If you do something that looks or smells like retaliation, they're likely to be all over it.
Okay. Last question that we have, and you guys kind of covered it towards the end of the presentation. Will there be any guidance given on requirements a company is obligated to make as employees return to work, sanitation, masks, gloves provided, etc.? I know there are organizations out there such as the Chamber, the Greater Houston Partnership, and similar organizations that are collaborating, that are putting together return to work safe programs based on recommendations by the governor and the county judges and whatnot. But is there any other information that you guys could provide regarding that?
We actually have a 5-step to reopening article on our website that one of the members of our safety team just prepared a few days ago. And the CDC also has some guidance about returning to work on, I think CDC and OSHA may have it.
Sure.
But I'll be glad, Matthew, to send you a link to that article that I mentioned.
Please do.
Share that with anybody who's interested in it.
Yeah, I'll pair it with the slide deck and we'll send it out. Yeah, absolutely.
We also, I think today or last night, our task force that Kevin spoke about came out with a checklist, a return to work checklist. That's, you can take what you need that will apply to your business, but Fisher Phillips has kind of given that away freely for employers. So I think we could send that as well.
That'd be fantastic. What we might end up doing is creating a landing page on our website for all the content. We'll even put the recording of this presentation on there as well, and link to the resources that you guys provide under that so others can get the access to it as well.
And that stuff's all free.
Sure. Well, I appreciate that. Thank you. And thank you for giving your time today, your industry expertise. Very, very informative presentation. I hope all of our attendees are on the right track regarding everything. And there's a lot of information, as you said. So if there's any other questions that people may have, obviously their information is up on the screen. If you need to get in contact with them and lose their information, feel free to contact the Katy Chamber and we'll connect you guys accordingly. Outside of that, if you guys want to make any last statements, feel free to. If not, we'll go ahead and close this presentation up.
Great. Well, I just want to thank everybody for participating today. Thank you, Matthew, for hosting us. And I do want to say a word to my cohort, Lariza. She's done a great job in working on this stuff for several weeks now, and she's become quite a good resource. So thanks, Lariza, for all your contributions to this, and thanks everybody again for attending.
Thank you, guys.